Good afternoon, everybody. We're just going to give it a couple minutes to let everyone join, and we'll get started. Let's give it another minute or so and let people join, and then we'll get going. Okay, it's 12:03. We'll get going. Thank you very much for joining us today. My name is Zach Zylkowski. I am the Director of Municipal Affairs at Alberta Council. So for those of you who haven't sat in on one of our webinars before, Alberta Council is a legal and lobby firm located in Edmonton. We do a lot of work with municipalities, including putting on webinars such as one today, which we will be talking about Bill 50, the Municipal Affairs Statutes Amendment Act that was introduced last week. As I get going, feel free to put a question in the chat. If you have any questions at all, I'll get to them probably as I skip around in the screens. So feel free to just put it in whenever it comes to you, and I'll address them. This webinar is also being recorded, and it'll be available on our website at albertacouncilnews.com probably later today. If any of your colleagues missed it or want to follow up, it'll be available. Great, let's get going. So there's about 9 key areas of change in Bill 50. So it deals with things like ICFs, Council Code of Conduct, meeting procedures, CAO accountability, official administrators, regulation making authority, administrative election changes, campaign fund transfers, elector assistance terminals, and the NHBPA and Safety Codes Act changes. First one up is ICFs. So changes to ICFs are obviously affected in the legislation of the Municipal Government Act. And so what it's doing is adding provisions that all ICFs must address following services, including transportation, water and wastewater, solid waste, emergency services, and recreation. Services that are not in the mandatory list of ICF services will not be subject to arbitration. Arbitrators' decisions, the change is being made so that arbitrators' decisions must be implemented as ICFs, and the minister may impose if not adopted. There's some changes to capital cost. So if all municipalities party to an ICF agree, then additional services may also be included in an ICF, except for third-party services. Sorry, that's not as cost sharing, that's just services. So you can include additional non-mandatory services, just not third-party ones. In terms of capital costs, so capital cost inclusion requires prior agreement on participation and input by all participating municipalities on design of and decision whether to build a facility. What that means is that in the past, there were some ICFs agreed to between rural and urbans where capital cost inclusion was included in the ICF. And then in the future, a new facility was being proposed, and one of the parties to the ICF had no ability to provide input on the design and whether or not it should be built. So this is requiring municipalities to have input into the construction of, as well as the design of any facility in order to be required to contribute to the capital cost. You may also establish a cost calculation model within your ICF now, and municipalities must disclose all information, data, or assumptions used for its proposal in cost calculation. Another change is that any two bordering rural municipalities may opt out of an ICF by mutual agreement after first reviewing all existing agreements between them. So there, before Bill 50, if you had a contiguous border, you must have an ICF. Now they're changing it so that, potentially there is two rural municipalities that have a border, but they do not share any services whatsoever. So in that case, they may opt out of an ICF where it doesn't make any sense. If you do decide to do that, you have to review all your existing agreements first, as well as let the minister know, and then post something on your website justifying why you don't have an ICF. Next up is Councillor Code of Conduct and Meeting Procedures. So obviously, again, the MGA. So the removal of the mandatory Councillor Code of Conduct shifts responsibility back into elections. They have indicated that if there is a significant issue with an elected official, then every 4 years we have an election and the voting public can change their minds. What this means in legislation is that any municipal bylaw or portion of a bylaw or a resolution that provides for a code of conduct or addresses behavior of conduct of a councillor is repealed. Any existing complaint or imposed sanctions related to a code of conduct bylaw are terminated unless they are already before the courts. And a council may not make a bylaw or a resolution that addresses the behavior of a councillor or members of council committees. And the minister will establish standardized meeting procedures for councils and committees in the future. They have also indicated that they are planning on implementing an integrity commissioner for the province, where complaints will be addressed by a provincial integrity commissioner. But that is not in the legislation, and it's not anywhere except for the fact that the minister said it. So some changes to CAO accountability as well. So it adds a provision that CAOs must provide information to councillors upon request as soon as it's practicable. The CAO may decline to provide information in specific circumstances, but the CAO must provide the reason for the refusal to all councillors. Information shared with one councillor must be shared with all councillors within 72 hours. It's also adding a provision that a written report to council on natural person powers use is required within 72 hours. Some changes as well, that a municipality may only appoint one CAO. And a council decision to appoint, suspend, or revoke the appointment to the CAO must be by simple majority only. There's some questions in the chat about the previous slide. Very concerned about the removal of the councillor code of conduct, as I have a rogue councillor. Yes, there has been some indications from municipalities that it's not great that the code of conduct is being removed. I think there has been significant discussion over the last several years that the code of conduct has been weaponized by various councillors or members of the public, and what we had wasn't working. So the minister had heard that from various sources across the province, that the code of conduct necessarily wasn't being used the way it was intended. So I don't know what the answer to that was, but the chosen path the Minister of Municipal Affairs has taken is to remove the code of conduct from individual municipalities. He will set a province-wide standard for municipal councilors as well as members of committees. Yes, it is a change. We'll see if it's one that will work well, or if we will run into the same sort of issues. Another question is, why are codes of conduct being repealed before the provincial replacement is written? It's a wonderful question. I have no idea. But I think that the intent would be to have a new set of provincial code of conduct, not rules, but regulations, I would assume, following the next election. What would encompass natural person powers? So I had the same questions. I had to ask one of our lawyers because I didn't know what it meant. But basically what it means is that if the CEO signs something like an agreement on behalf of the municipality, they would have to notify or like execute a contract or enter into a new contract on behalf of the municipality. That would be exercising natural person powers. Does this mean meeting procedure bylaws are not allowed either? You are not allowed to set bylaws. Where is the exact wording? You may not make a bylaw or a resolution that addresses the behavior of a counselor. So if your meeting procedure bylaws addresses behavior of a counselor, that wouldn't be approved. Do things like counselor attendance standards, a minimum number of meetings that must be attended counts as council behavior? It's a great question. I'm not a lawyer. I will caveat all of my responses to that. But that would be something to look into for sure. Great. Those are all the questions that I have in there. We'll move on to the next slide. Find it. Official administrators. So this is when an official administrator has been appointed to work with the municipality. So this expands the oversight role of OAs significantly, including financial co-signing and access to closed sessions. So an official administrator must be notified of any council meeting and may be present for any meeting of council that is closed to the public, except in cases of legal privilege. It also provides authority for the official administrator to direct the municipality to provide a copy of any records, except records that are subject to legal privilege. And an official administrator must sign or authorize agreements, checks, or other instruments of the municipality in addition to the person authorizing. So those are specific rules around OAs. Some changes in the regulation making authority of the minister and lieutenant governor. So this grants broad new authority to the province to define public interest and what counts as government policy. So this is one that doesn't look like it's a massive change in the legislation itself, but it has potential impacts in the future. So the lieutenant governor and council can define public interest and policy of the government. Public interest definition is deferred. Policy of the government will include formal instruments like acts, orders, etc. Is it expected that council repeal the code of conduct by motion, or codes of conduct now fully washed by the Minister of Municipal Affairs? So once the legislation is proclaimed, all codes of conduct are repealed. Let's see if I can find the actual line in here. I can't find it super quick, I'll move on, but there's a line in here that states exactly how it works. Few seconds, sorry for the dead air. Okay, so So it says a bylaw or any portion of a bylaw or resolution or any portion of a resolution passed by a municipality prior to the coming into force of the subsection that provides for a code of conduct for councillors or members of council committees who are not councillors, or addresses the behavior or conduct of those councillors or members, and that was in effect immediately before the coming into force of the subsection, is repealed on the coming into force of the subsection. So essentially, oh, thanks, Aaron. Just as I read it out. Essentially, what it's saying is that it's automatically repealed. It also says that a council must update its bylaws respecting procedures for council and council committee meetings, if any, within 6 months of the date of an order made under subsection 4 to accord with that order. Hopefully that answers your question. Are there any boundaries of what is allowed to be requested by a councillor and has to be provided within 72 hours? So that's not the way that works. The legislation says that, hold on, just keep scrolling. The legislation says that a CEO must report back to council in a reasonable amount of time. And then once he reports back to that councillor that requested the information, that the CEO then must provide the rest of council that same information within 72 hours. So there is some qualifications in here that if you want to see what the exact qualifications are, but there is provisions for what a CEO may decline to provide, including it's like stuff that's not FOIPable, but essentially if it is FOIPable, then they must provide it. Does that include code of conduct for public committee members? Yes, if it's a council committee, you're not able to have a code of conduct for members of council committees. Change of procedure bylaw says within 6 months of a date of order. Code of conduct that a library board has, will this still apply to a councillor who sits on that board? It's a good question. I'd have to look to see how a library board is actually enacted. If it is a council committee, then yes, it would apply. But if it's set, it's probably set under the Library Act, so I'd have to look into how it's set in the actual Library Act, because if it's a separate entity, then it doesn't apply. Yeah, SDAB probably would fall under council committee. Okay, next up is election administration updates. So this is obviously under the LAEA. So this is mostly cleanup and modernization. It adds provisions to allow residents of Jasper who remain temporarily displaced to vote and run in the upcoming local election. So it's not just for voting, but it's also if you want to run in Jasper. You basically just have to sign a declaration that you're intending to return to live in the community. It also splits up the provisions for the current recount processes into separate sections. It's pretty kind of semantics. It also changes the candidate withdrawal provision. So you may withdraw your name as a candidate during the nomination period or within 24 hours after the closing of nominations. The change here is that before this bill, you could only withdraw if there was a sufficient number of names as candidates, and now it doesn't matter, you can still withdraw. It also provides authority for a school board to request permanent elector registry, which changed in Bill 20 that you must now have as a municipality. It also updates the definition of campaign expense to include references to a local political party or slate. That's obviously for Edmonton and Calgary, and then update the definition of contribution to include references to a local political party as well. Some changes for campaign fund transfers. So this is obviously surrounding Edmonton and Calgary, but it allows fund transfers between local parties and their endorsed candidates. The transfers must be reported in annual disclosures. However, the way that I'm reading this is that there's no limit. Actually, it clearly states that there's no limit on transfer amounts between political parties and their candidates. But if the way I'm reading this is correct, they made specific mention in contribution limits to candidates, but they removed any specific mention to political parties. So I think that they've created a loophole whereby you have unlimited donation capacity to political parties, and then political parties have an unlimited transfer amount to candidates. So they created a contribution limit to candidates of $5,000 in the aggregate for every municipality, for everybody running in a municipal election in Edmonton and Calgary. So you can only donate $5,000 total to candidates. But I think they've left a loophole that you can donate as much as you want to political parties, and then political parties can distribute those funds. So if that's the case, so this way it's reading to me, that's a pretty big loophole in election financing rules for Edmonton and Calgary. Okay. Elector assistance terminals. So this is allowing municipalities to use elector assistance terminals so voters with visual or physical impairment can still vote in the election. There's quite a bit of rules around what you're allowed to use as a voter assistance terminal, but they must print paper ballots for manual count, cannot be connected to the internet. There's a couple of other things in there as well. And a bylaw must be passed by June 30th of the year in which a general election is to be held in order to be able to provide voter assistance terminals in your municipal election. Also, some changes to the NHBPA and the Safety Codes Act. That's how tabulators work. Yeah, I'm not gonna talk about voting tabulators. The voter assistance terminal must print a paper ballot that like goes into a ballot box and then are counted by hand in the count process. So this is just to help people with disabilities be able to participate in local democracy. So changes are kind of homeowner focused, but they will likely affect municipal permitting and oversight as it relates to the new home warranty program. So it allows owners who've been granted an exemption to sell a home, provided they provide the prospective owner with a disclosure notice in a form satisfactory to the registrar. What this says is like owner builders are allowed to have an exemption of a new home warranty. And then there's some requirements if they are deciding to sell that home while it's still under the warranty period. You basically have to provide notice to the registrar as well as a disclosure to the prospective buyer of your home to ensure that the prospective buyer of your home is aware that there is no home warranty on it. It also includes a financial hardship as grounds for receiving an exemption, which is new. It adds a responsibility for the registrar to register a caveat against a certificate of title to the land on which the new home is the subject of the warranty exemption. So essentially their registrar will have an interest in the property when there's no new home warranty. So requirement to provide that disclosure to a prospective homeowner is a bit of a double a safety net because not all new homeowners or home buyers are looking at or pulling title. So there will be a caveat on title, but you're also going to be required to provide that information in a disclosure. Appeals mechanisms are also reinstated for registrar decisions. It also includes some stuff about minister may seek advice from the council on inclusions in the Safety Codes Act. So that's it in terms of the actual changes. This bill is actually not super complicated. It essentially makes a lot of administrative changes and then some small changes to ICFs. And then the big one is obviously the code of conduct being removed. But essentially it's not like Bill 20. Bill 20 made a lot of significant changes to the way municipalities operate. But this one is smaller. So I don't think there's anything in here that should be all that surprising for municipalities, except for probably the entire removal of code of conduct. With the removal of code of conduct, council is not able to come after staff. Yeah. No, I don't think they're able to come after staff. Is there a summary of the Bill 50 changes available somewhere? Yes. I have a briefing document I put together for our municipal clients of Alberta Council, which Aaron, maybe we can send out to everybody that registered. If they're interested in it, we can flip it to you. Does the bill eliminate the ability to manage meeting conduct? I think the bill is designed to prevent municipalities from individually managing councillor behavior. What happens in the interim if there are code of conduct violations? So once the bill is proclaimed, there will be no such thing as a code of conduct violation, given that the resolution or bylaw that your municipality has surrounding code of conduct will be repealed. And the provision is written that any ongoing code of conduct investigations or sanctions are automatically void. And you have guidelines for code of conduct without having disciplinary measures. No, this makes no reference to disciplinary measures whatsoever. It specifically talks about code of conduct as well as behavior of councillors being removed. Go to court. Yeah, sure. Natural person powers amendment is very impactful. MPPs are exercised by time. Very heavy administrative burden. I would imagine so. The question will be whether or not all you have to do is notify. If all you have to do is notify council that has been undertaken, hopefully that will be less burdensome than having to provide a full report. Does Bill 50 repealing the code of conduct bylaw affect the council orientation training requirement to partake in the training versus the municipality offering it? No, that doesn't change. The only thing that they changed as it relates to orientation is that in the existing MGA, there is a sub provision in the council orientation training that you must also train the code of conduct, and they are removing that item because there will be no such thing as a code of conduct anymore. Do you have to make a motion to repeal the code of conduct? No, it just is void, but you could. Violence and harassment policies, as long as it's not bylaw resolution, probably, but I don't think there's anything you can really do about it. A few examples of natural person powers. If you enter into a contract by saying the city of Edmonton is agreeing to build a road, then you are signing as the municipality and not as the CEO, I think, is the way that works. Does the bill eliminate the ability to manage meeting conduct? I think you can manage meeting conduct, but you can't have a code of conduct. So you're not going to be able to sanction anybody because they violated a code of conduct, because there will be no code of conduct. The recording will be not sent out. It will be available on our website. So albertacouncilnews.com is where we have our news articles, and all of our previously recorded webinars will be on there as well. I can list the mandatory services under our ICFs. 1 second. Transportation, water and wastewater, solid waste, emergency services, and recreation. So again, those are the mandatory included services that you must have in your ICF. If all parties to the ICF agree, you can include further services as long as they're not third-party services. When do I plan on having this bill proclaimed? I don't plan on having this proclaimed. It is, I think, currently in maybe second reading. So the legislation hasn't even been passed yet. It has to get passed first before it's proclaimed. What are the long-term goals associated with the legislative change as it relates to removal of council code of conduct? That's a great question for your local MLA / the Minister of Municipal Affairs. I do not presume to speak for the Minister of Municipal Affairs, but if I had to guess, it is because it was being abused and they needed to make some changes. Yeah, I think that's a great point. So having to amend several bylaws, policies, and get potentially a legal opinion, I think that's a great idea. Again, caveat, I'm not a lawyer. This is my interpretation of the bill through my experience of reading and working with legislation. Again, I am not a lawyer. So if you do have specific questions, then I would recommend speaking to your legal counsel. Alberta Council also has a legal team that would be able to help you with that. If you would like to speak to them, let me know. That's a pretty technical question, Kate. I think you would need some guidance on that. What is administration's option rather than putting a code of conduct for council? Your option is to wait for the Minister of Municipal Affairs to pass a regulation that includes a standardized code of conduct for municipalities across the province, which will be forthcoming, potentially forthcoming according to this bill. The minister may do so in the future. What the indications are that that's the intent. Do I have any indication that municipal affairs might be willing to hit pause and listen to the obvious concerns of communities expressed here today? Yep, doubt it. No, I think that there has been actually significant, we've been hearing about this for years and years and years, especially elected officials have had a really big issue with the code of conduct. And I think minister has been very clear in discussions, at the Alberta Municipalities Conference or RMA conference, that code of conduct needed to change, and this is the path that they have chosen. So I think there's probably a varied opinion as it relates to whether or not this is a good thing. But no, there's the intended path, I think. Any other questions for us? Seeing none, thank you very much, everybody, for joining us today. If you do have any questions, my email's on the screen. Feel free to send me a note. Aaron, I think, sent out the briefing document already, and the webinar will be available online later today or early tomorrow. Thank you very much for joining us, and yeah, have a great day.